Good afternoon, everybody, and welcome on behalf of FSBPT. My name is Nancy Kirsch, and I currently have the pleasure of serving as the president of the board of directors of FSBPT, and it's really wonderful to have you all here with us this afternoon. Before we actually get started, I want to give you just a little overview of what's coming up, kind of whet your appetite of what's coming in the future. Next week, we have Jonathan Webb exploring unconscious bias. And April 7th, Harvey Aikman and Kathy Arney and Tom Pennington will be joining us for promoting prevention through practice advice. And then the following week on April 14th, Justice 3D for an overview of trauma's impact on boundary violation investigations. And then at the end of the month, Dale will be back with us again for Don't Stop Us Now, We're on a Roll, and we're on a roll, rolls and hats. But today we're here and Dale Atkinson is joining us for How Do Regulators Meet Their Obligations? Dale is no stranger to us, thank heavens for that. He's managing member of Atkinson and Atkinson in Northbrook, Illinois, and he represents regulatory bodies and boards, which he will tell you more about in just a moment. And he's a graduate of the Northwestern School of Law in Portland, Oregon. And he's our go-to for regulatory training. And every single time I have the pleasure to hear Dale speak, I learn something new. And I'm always walk away with great and valuable information. So I will take no more of his time up and welcome him and thank him for presenting this afternoon.
And thank you, Nancy. And with that invitation precursor to these upcoming webinars or Zoom calls, I applaud FSBPT for bringing the regulatory community together on a regular basis on these ongoing topics. And so, I'm happy to be here. And Nancy, thank you for that introduction. I'll start out by welcoming everybody to what, for me at least, are monthly Zoom calls with various topics, and I'll discuss those in just a minute, but I'm happy that you're here and that you're willing to spend a little bit of time, of your valuable time, hearing a little bit about the regulatory community and some of the regulatory issues themselves. I also want to start out by a big shout out, thank you to FSBPT and its board of directors, as I've mentioned, for holding these Zoom calls and webinars to provide opportunity for valuable exchange of information. A big shout out thanks to the staff of FSBPT for putting this together and technologically helping us along. But the biggest thank you goes to those of you who are on the line today, the regulators. You're not thanked enough for what is an important role that you play in regulating any profession, whatever profession it might be, and obviously in this case, physical therapy and physical therapy assistance. And you're just not thanked enough. And really right now, the regulatory community is under such scrutiny that you're sometimes thanked by legislative questions, sunset processes, litigation filed against a board and what have you. So your important role is not overlooked by me, and I will take the time to give a shout out. Thank you. And the last introductory comment to get us kind of started here is as I do these, I might pick on a jurisdiction or two based on statutory language or otherwise. So hopefully that's taken in with a grain of salt and also in a productive, constructive way as well. So we might have a few citations to statutes that come up just to identify some points and that we all can learn from as we go along. So as mentioned, I'm Dale Atkinson. I'm an attorney just outside of Chicago. As the introduction said, I could put a list of a lot of clients up here, and I've chosen not to. By the way, that picture is not me, although for some reason I look at it and I thought it reminded me of me. But the gist of what it is that I do for a living in representing regulatory associations like FSBPT, and the importance for you all to know is that you're not alone as a regulator. So you have other people on this call today. You have the FSBPT and their staff and your connections you develop through them. I encourage you to take advantage of that. But FSBPT has other FSBPT-like organizations that it also can communicate with. So my practice, I do represent organizations like yours. These are not-for-profit generally 501c3 organizations whose membership are comprised solely of the regulatory boards from all the jurisdictions in the US and perhaps internationally as well, including North America, Canada, and otherwise. And they provide programs and services that are intended to lessen burdens on state government. And the reason I stop a little bit to talk about that is sometimes maybe we all don't step back enough and realize the importance of FSBPT-like organizations. And so they do provide programs that are intended, again, to make your lives easier as regulators, whether you're a board member, staff, administrator, executive director, investigator, assistant attorney general, or otherwise. Again, welcome to these calls. Thank you for what you do, and understand that you have each other to lean on, but you also have FSBPT-like organizations, and in your case, FSBPT. So the signature programs of most of my clients is the development, administration, scoring, and maintenance of a uniform licensure exam. So the whole psychometrics that go behind validating an exam program for use as a demonstration of entry-level competence. You all then, of course, rely upon that as a basis for making a licensure eligibility determination, along with other criteria that might exist. And so we're all in this, so to speak, together. We can learn from each other. And the idea behind these sessions, all of them, is intended to provide an opportunity for us to interact with each other. So with that said, we do ask that you participate. I've done multiple ones of these already for your organization, and we encourage you to use that chat feature. So if you've got something to say or you want an issue addressed, please feel free to type it in there. Raise your hand. I think there's ways to unmute you, perhaps, and otherwise, but the staff is keeping an eye on that. I also can see the chats as well, and I'll try to address them as they come up. So we do want this to be interactive. We do want you to walk away from this feeling like you weren't just lectured to, but you actually digested some of the concepts, perhaps put something in the chat, asked a question, what have you. So let's, when we come out of this, feel like that we've met that obligation. So to get us started, and just to get this chat room warmed up, I want anybody that's interested, type your favorite musical group or artist into the chat feature. It's got nothing to do with regulation, but it tells me you're out there listening and that you're participating. This is why, by the way, I don't try to be funny anymore, tell jokes. I can't hear you laughing or others. So I can see a few coming up here as well. James Taylor, what a great choice that is as well. So this shows that you're listening. This shows you have the ability to participate. And that you can write something in here. So I can see a bunch of them coming up now. So congratulations to you, Steely Dan. That would be one of my choices. I just saw that come up. So believe it or not, Bob Marley and Steely Dan would be my two. So a little bit of a recap, and this probably should have been, this slide should have been titled maybe forecast. But the last session, we talked about the purpose of regulation. Let's meet for a purpose. Why does government exist? Today, we're going to talk about know-how. How do regulators meet their obligations? And although these build upon each other, I do encourage you to attend any or all of these that you're able to. You can spend an hour with us and we can have an exchange of data and information. But as mentioned, the next one is roles and hats. Together is better collective wisdom. We'll talk about conflicts in the future. We'll talk about what makes regulators tick, statutes, regulations, policies. Here come the judge. We'll go over some cases that have come up. I want in applications and renewals, standard operating procedures, what it means to be efficient, say what, communication protocols, and then we'll do a kind of a review at the end of the year. I believe that would be the December session itself. So this is what's to come. As I mentioned, it does build upon each other, but they're all independent. You can feel free to attend any or all of these, and there will be a little bit of overlap between each of them. So in this session, we're going to address how regulators meet these statutorily established obligations. And the easiest way to say that how do you meet these as well as to say, is to understand and fulfill those obligations. Okay, so by the end of this session, hopefully you'll have a little better understanding, or maybe perspective is a better word to use there, about the obligations that are imposed, if you will, upon you related to your role as a regulator and a regulatory board itself. So I'd like to start with talking about delegation of authority. And this is probably something that we don't spend enough time on. The administrative arm, if you will, of government is sometimes been called the fourth branch of government. We have a legislative branch, we have an executive branch, we have a judicial branch. And some people like to argue, at least, that the administrative arm is a fourth branch of government. It isn't, but obviously arguments can be made that way. And the reason that I start with this is because you would not exist as a regulatory entity without legislative action. So you're not another branch of government. You are delegated with authority through a statutory enactment. So a board is created and it is given authority to act based upon that statute. You as a regulatory board can only do what's within the confines of that statute itself. And so that delegation of authority is an important concept to make sure that we understand that, again, you wouldn't exist without legislative action, and that legislative action sets forth the parameters under which you can act here. Excuse me. Now, delegation is another important concept because it has legal connotations. What can be delegated to you as a regulatory board through that statute? And how descriptive or draconian can those statutes be, or should they be? Theoretically, you are delegated with the authority to enforce the Practice Act within the intent of the legislation, ultimately protecting the public through regulation of the profession, in this case, physical therapy. We need expertise to do that in an efficient manner. Therefore, that delegation is given to you as a board to promulgate regulations. And those regulations have force of law, just like the statute does, but those regulations are adding meat to the skeletal bones of the statute itself. So that's another delegation issue, that you are given the authority as a regulatory board to promulgate regulations that give more descriptive identity to the profession itself. And it provides, again, for a regulatory structure around that. You're also delegated with all the other authority: grant a license, renew a license, continuing education, continued competence, investigations, adverse actions or discipline, enforcement, communications with the outside world, media, social media, or what have you. And so all of this is created through that statutory authority. Just one more point about delegation. Then you as a board delegate to your staff certain obligations or rights, if you will, that are undertaken in between the board meetings itself. So it may be granting licenses where there's no red flags related to them. It may be renewing licenses where there's no red flags. It may be to initiating investigations and otherwise, or starting the enforcement processes or anything else, or dealing with the media or outreach. So this delegation of authority is really an important place to start when we talk about how it is you meet your obligations as a regulatory board. And that's understanding this concept. And that, again, as I've mentioned, I don't know if this is really just talked about enough. So we're going to start this out by addressing delegation of authority. I've already mentioned this, but I'll put it in a slide. And by the way, the slides are available to you as the attendees. So FSBPT has these slides. I did add a couple of slides since I sent it into them, so I'll give them an updated one. But if you would like these slides, feel free to touch base with the FSBPT staff and they'll be happy to help you. But so these statutes are enacted and they protect the public by creating the board and authorizing it to regulate the profession consistent with the intent of the legislation. There's an elevator speech for you if you like it, or add whatever words that you like, but understanding this whole concept of the statutory enactments and the delegation of authority to you as a regulatory board, the important role. So we have an issue here about know-how, and I have to move these boxes so I can actually see these slides a little bit. So is understanding the parameters of the law itself. So here's what we're going to cover for the next several minutes: is understanding the parameters of the law. Be the regulatory experts, not the practitioners. Although many of you are licensees, and I understand that boards are comprised of both licensees and so-called public members, I like to suggest that you're all public members, but some of you have expertise within the profession itself, and that is needed. It's essential to the efficient operations of an administrative structure within government. But be the regulatory experts, not the practitioners. And if you lose sight of that role, which is, by the way, the next month's presentation, if you lose sight of that role and you mix up those hats, that is what creates legal issues that will cause litigation and otherwise. That certainly is what caused the North Carolina State Board of Dental Examiners case under the antitrust laws where the FTC sued them, decided back in February of 2015. But understand that role as a regulatory expert, not as a licensee / practitioner. And then know when to ask questions, okay? Be careful channeling the inner lawyer in all of you where perhaps you want to be, but know when to ask those questions. So we'll kind of cover these roles that exist now. So let's start with understanding the parameters of the law itself. So there's a Practice Act, as I mentioned, that creates and defines you and your scope and roles that you do play. Within that Practice Act, there should be definitions. Now, I'm a big fan of definitions, and I suggest, and with all my clients when I'm assisting them in their model legislation, is that we have a robust set of definitions. We develop the Model Practice Act, and once we are so-called finished with it, we go through, identify those important terms, and create a definition section at the start. I'm also a fan of capitalizing defined terms so that if I see a capitalized word or phrase anywhere in the Practice Act, I know I can find it in the definitions. It's an easy cross-reference, and therefore we can use that uniform phrase or word throughout the entire Model Act or through the acts that you may have at the state level. But again, it provides that uniformity, and sometimes it makes it a bit easier to understand if that phrase or word is not redefined throughout the act, because somebody's going to miss it or we're going to define it differently elsewhere. So definitions are absolutely critical in my mind. You all know that the scope of practice is extremely important and how that's defined. So that will be contained in the Practice Act itself. Enforcement or grounds for adverse action or discipline, of course, are going to be in there. And there are many other aspects to a Practice Act. So I just identified a few that I think jump up as probably the most important areas that need to be identified. Of course, the composition of the board exists, the outreach of the board, the publications, the involvement of social media and with the media, as well as many other factors, including the promulgation of regulations. So that Practice Act is something that should be reviewed and looked at by you as members of member boards or as staff of member boards, or perhaps as investigators or assistant AGs. And so get used to reading the Practice Act. You'll rely upon your lawyers for certain areas of interpretation, but in the end, it's ultimately the responsibility of you as the board collectively to interpret that Practice Act, especially if there's an ambiguous phrase in there, and there always will be, or if there's a misunderstanding or a way to interpret something multiple ways, you all will ultimately make that decision. So you need to have some familiarity with that Practice Act. They're boring to read. Some of them are extremely poorly written. We understand that, but that's the parameters with which you live as a regulatory body. Under the number 2 there, duly promulgated regulations, you have the authority to promulgate regulations, and we've already identified they add structure and meat to the bones of the Practice Act itself. And the legislature should not be involved in some of the nuanced areas of practice because they don't have that kind of expertise. So the Practice Act should be very skeletal. The promulgations add definition and add specificity, if you will, to that skeletal Practice Act itself. You have to know that you are acting within the authority of the Practice Act when you promulgate a regulation. And so your lawyers will advise you as you go, but the promulgation of those regulations have force of law, hence why they follow the formal process that they follow, and they add those details as we've talked about. Many of the cases that I see dealing with promulgation of regulations, cases meaning judicial decisions, many of those cases are driven by, does the board have the authority, or are they acting within the authority? I should more specifically say, are they acting within the authority of the Practice Act when they promulgate that regulation itself? So get advice on that, but plow ahead and do your jobs using the expertise you bring to the table as the board. And then lastly, there are other laws that apply to you: Administrative Procedures Act, disabilities laws, ADA, open meeting records, and open meetings and open records laws, and otherwise. And so at least have some familiarity with the law itself overall, Practice Act, regulations, and other laws. Lean on the lawyers when you need to for that assistance, but know they do exist. So then eventually we're going to read these practice acts. This is out of your model act itself. This is disciplinary actions upon proof that any grounds prescribed, et cetera. The board may take one or more of the following actions. And I've highlighted number 4 only because I would just say, for those on the line, what is revocation? Okay, what does that mean? Right above it, it says suspend. And so we all step back and eventually ask the question, well, gee, what does revocation mean? And if we are going to impose it upon someone, what are the consequences to us as the regulatory body itself? So take your pick on what you think, or ask the questions, or maybe you have already asked this question, but you've probably, those of you who have heard me before have probably heard me say, I'm not a big fan of revocation unless it's permanent. And ask your lawyer that question. Can we permanently revoke a license? Meaning this licensee now will never be relicensed in our jurisdiction ever again. It's probably frowned upon by the courts, but some jurisdictions you can revoke permanently. In many, you cannot. But the question is, what are the consequences of revocation? So this, again, this is just an understanding issue on the know-how of how to be a board member and fulfill these obligations. And it's understanding what these terms mean. So if you revoke someone's license and they continue to practice, what do you have? Perhaps an unlicensed practice question, right? Now, does your board have authority over all persons and not just licensees? Ask yourself that question. And the answer may be no to many of you on the line today. And if you do not have administrative authority, now that revocation of licensure just divested your board of the authority to continue to enforce something. Suspend a license perhaps is different, right above it, number 3. And perhaps you can make a much stronger argument that you have authority over someone who has a suspended license, and they need to come back to you to reinstate that license in a manner where they are able to lawfully practice. So this is just one small example. It's actually a pretty big issue in my mind, but it's just one small example of, if you read through your Practice Act, you will likely come up with some questions. And the idea behind my remarks are to stimulate you to think about what those questions might be. You'll eventually get them answered. They don't all need to be answered at the same time. But again, it's a knowledge-based issue that comes up. And so you can read through your own Practice Acts and figure out what may pose questions to you. Now, here's an example of, and this is out of the Virginia Practice Act for physical therapy. And it states that it shall be unlawful for any person to practice physical therapy or as a physical therapy assistant in the Commonwealth. So there's one identifying issue within the Commonwealth itself, without a valid, unrevoked license issued by the board. So you can read that and say, well, what does that mean? What is a valid, unrevoked license? And does that eliminate the consideration of all the other potential sanctions that might exist? Suspension, restriction, censored license, and what role do those words play in this? And I'm not saying this to be critical. I'm saying this is, and I read a lot of Practice Acts, and many of them have language in them that kind of are head scratching to me, and they may be there for a reason, those words. And so we would ask, well, why is this in here? You could say without a duly issued license, or without a license duly issued by the board, but a valid, unrevoked license. And if the courts are ever asked to interpret this, they will assume those words are in there for a reason. What does valid mean? Think about it. What does unrevoked mean? Think about it. And therefore, we as a board potentially have the right to enforce unlawful practice-driven issues, or at least this is trying to say that you have to have a license in order to lawfully practice. So think about the language as you read your Practice Acts. And I know all of you are going to, as soon as this presentation is done, is going to fire up your Practice Act and start reading it. And hopefully you're all smiling about that. But it is a worthwhile read, and it is worthwhile to digest some of the words used. And this is one example. Continuing on in the Virginia statute, the board shall promulgate regulations. So this is just an identification of the word shall and the word may. So the board shall promulgate regulations establishing requirements to ensure continuing competence, And some people debate continuing education versus continuing competence. And then it says those promulgated regulations may include continuing education, testing, or other requirements as the board determines necessary. So here is a true issue of you shall promulgate regulations, and here's some suggestions of what it might cover. And the board then is obligated here to promulgate regulations, but it's not obligated by statute as to what to put in those. But you can see here, continuing education, it says testing. So might there be an examination used as part of a continued competence determination that's ultimately made by the board itself? But may, shall, those will eventually jump off the page at you when you read your statutes, and you'll start to identify. Now, I do see, and I'm not suggesting Virginia does this, but I do see many times where the statute says the board shall promulgate regulations to address something, and the board never promulgates those regulations. That does happen. And ultimately, if there's litigation about something, there will be some legal issues that will have to be ironed out if that is argued. So moving on kind of to the next topic itself is the be the regulatory experts, not the practitioners. So we need to understand here, as we identified in the last session, the role of government. And government is intended to address the needs of society as a whole. And in your case, they have enacted statutes that are intended to protect the consuming public, and they delegate authority to you as a board to enforce that, using the expertise that you do bring to the table. And as soon as government gets involved, and there's the issuance of a license or the mandate of the issuance of a license before there can be lawful practice, that triggers the fact that applicants and licensees have certain rights, because the failure to receive that license might stop them from practicing their profession, their chosen trade, occupation, or profession itself. And so an important role that government plays is to determine that this profession is in need of regulation. And that is in your Model Act, and it should be in your statutes within each of your jurisdictions to identify the fact that physical therapy is in need of regulation in the interest of the protection of the public health, safety, and welfare. And that should be in there. It is not in many statutes, but it should be in there. And the other issue that should be in there in this declaration of the government's interest is that it is intended to limit the number of practitioners based upon criterion that is set forth in that law itself. And so not everybody can be a physical therapist. They must have an education exam, application, good moral character check, and everything else that goes into the determination of issuing that license itself. So it does trigger rights. That's okay. There's nothing wrong with that, but that's the role government plays. The role of the board is to carry out the intent of that legislation. We've emphasized that already. And ultimately, the role of the board members, you all, is to understand what it is the board does, why it does it via government, and to ensure that you wear the appropriate hat when undertaking board business. You're not promoting the profession. You're not a trade association. You're technically, in my mind, not necessarily even a licensee, but you do have expertise in the profession that you bring to the table. Now, I say the licensee part, understanding that you may have to be a licensed to be on the board itself. I get it. But the point is that understanding what role it is that you play. And if you choose to venture outside that, you do create potential legal issues for the board itself, for you individually, or the decisions ultimately made. Grant a license, deny a license, renew a license, deny a renewal, investigate a complaint, administer an adverse action against a licensee or an unlicensed person, if you are able to do that, and assess costs and or fines. But the potential for challenge there is dependent upon you understanding the role of government, the role of the board, and your individual role as a board member. And we'll discuss that in the upcoming sessions as well. So stolen from one of my clients is this legislative declaration. I've mentioned that it should be in all the practice acts. So this is out of ASWB, which is the Association of Social Work Boards. This is the equivalent of FSBPT, but in the world of social work. And they provide the same kind of lessening burdens on state government that FSBPT does. They produce a Model Practice Act, which this is part of it here. They also have an examination program used by all the jurisdictions in the United States and many of the provinces in Canada. So they are the equivalent of you all, but read this legislative declaration. This is their model act. The practice of social work in the blank of blank is declared a professional practice affecting the public health, safety, and welfare, and is subject to regulation and control in the public interest. There's a great statement that should be made to indicate the intent of the legislature. It's further declared, keeping reading here, further declared to be a matter of public interest and concern that the practice of social work as defined merit and receive the confidence of the public, and that only qualified persons be permitted to engage in the practice. And then finally, this act shall be liberally construed to carry out these objectives and purposes. That last sentence is extremely important. Liberal construction, meaning if there's an ambiguous phrase that is challenged and it ultimately goes into the judicial system for interpretation, that liberal construction is an indicator from the legislative branch to the judicial branch to give leeway to the board's interpretation. That is all about delegation. That is all about that, one of those first slides that we talked about. So this type of language is very important for setting the stage and protecting the potential of challenge to the statute itself. And then continuing on the next section, again, we're still with the ASWB Model Act here. And apologies for focusing on this, but I know this act well and actually drafted it. But the point being is that I think there's some important issues here to discuss. So the statement of purpose, it's the purpose of this act to promote, preserve, and protect the public health, safety, and welfare by and through the effective regulation of the practice, the licensure, control, and regulation of persons in or out of the state that practice social work within this state. So here they're being proactively saying, we understand the issues of technology, electronic or virtual practice that can occur not only intrastate, but interstate, and that we as a legislature are saying part of our purpose is to allow that control to be delegated to the board itself that's created. This could be human medicine, veterinary medicine, physical therapy, you name it. So you could take this language, steal it, and use it if you think it's going to be helpful. But it's important to understand, again, this legislative declaration and statements of purpose. These can be extremely important in the event of litigation. And we'll talk about a couple of cases coming up in just a minute here.
Dale, I don't know if you can see the chat, but there's a question. Could you comment on the term shall?
Excellent.
Plain language government
Sure.
advises that should be avoided because it's ambiguous and could mean may, must, or should. It advises use of must instead.
All right, so let's comment on the term shall. And they're saying that advise that shall should be avoided because it's ambiguous. I'm not sure if I would agree that shall is ambiguous and any different than the word must, but the short answer to this, and this might need a little bit more clarification, but the short answer to this is it's a mandate by the legislative branch telling the now delegated authority to a regulatory board to do something. You shall promulgate regulations. You must promulgate regulations. I would interpret the same way, that it's a mandate. So I'm not sure I'd agree that shall is ambiguous, but again, we could argue about this, but I think the shall is a mandate, as would a must be. And I'm hoping that's answering your question. So I would probably read those the same. I would suggest that if I'm drafting legislation on behalf of the legislative branch of government, that I would pick one, must or shall, and I would probably use it all throughout, assuming it works linguistically. But that's a good point. That's a good point. And what might that mean? The difference between must and shall. And if must is used somewhere in the statute and shall is used other, then that participant's question here is a good one. What's the difference? And why are they using different terms? So hopefully that answers your question. I'm glad that you typed that in. That means you're listening, and you guys are out there listening as well. I can hear you breathing. So thank you for that comment. And Nancy, thank you. Feel free to interrupt at any point in time, Nancy, if there's another comment that I don't see.
There is one that follows up in Kentucky. Shall is required action and not vague. Must, may, etc. is vague language.
Okay. So let's get the must and the shall people in the same room. Let them fight it out. You guys can figure that out. We're going to create a chat room just for the two of you. So, and there's a direction in the chat room now about selecting all so that everybody gets to see versus perhaps limited others. So carrying on here now in the role of government, I'm picking on Virginia again, and in reading the statute itself, under the qualifications for licensure, the criteria that must be met, under number 2, it says that you, under the education component, that you must be a graduate, you must or you shall, excuse me, that you are a graduate of a school of physical therapy approved by the American Physical Therapy Association. So as I was reading that, I scratched my head and I think, okay, so that's the trade association. So this is a delegation question, right? We've already talked about if the statute provides authority somewhere, that legislature is delegating to, as I talked about earlier, you as a board. So you have the authority to enforce the Practice Act. You have the authority to promulgate regulations. Here, the legislature is taking out of the hands of the board and saying, we by statute are saying that you must graduate from a program or from a school actually of physical therapy approved by the American Physical Therapy Association. Now, putting aside the issue of the role of APTA, the question that I ask probably, which I think is maybe more important, is should the legislation be identifying an entity in statute? I would suggest to you the answer to that is no. And a perfect example follows in the next section 3, that you as an applicant must have satisfactorily passed an examination approved by the board. So here the legislature has decided to identify the trade association related to education and identify that trade association by name, but related to an examination where there's a uniform exam program in existence, and maybe it didn't, maybe this predates it, but let's just keep going with my thought. There's a uniform exam program in existence put forth by the organization that the Virginia board belongs to. So it seems interesting to me that legislatively, they wouldn't recognize FSBPT's exam in statute if they were going to do anything in statute, but they chose to recognize the trade association. So now there's an asterisk under next to that number 2, because if you drop down there under that B, and the citations of statutes are right below that there, it says a physical therapist who has completed a Doctor of Physical Therapy program approved by the Commission on Accreditation of Physical Therapy Education, or has to obtain authorization, and the box is covering up part of that. But so now the point is the statute now says CAPD. So it's inconsistent with the non-doctorate degreed applicants for licensure. And I understand, I think you all are transitioning or already have to an entry-level doctorate program, but let's just run with this for now because this is a learning exercise for us. It's easy to criticize language. Okay, I understand that. So let's go back up to number 2, is a graduate of, and go back down to number B, physical therapist who has completed a doctor. So is there a difference between graduate and complete? And I only ask this because I'm a lawyer and this is part of our job, is to pick apart some of these words. But so then keep reading back up to number 2, is a graduate of a school of physical therapy, and back down to B, who had completed a Doctor of Physical Therapy program. Is there a difference between a school and a program? And I do represent accrediting bodies, by the way, so I understand institutional and programmatic accreditation and all that it takes here. But I'm just bringing this to our attention for purposes of being better board members. We're going to read these statutes and say, wow, is this really accurate? And if so, cool. If not, does it need to change? And if it needs to change, how do we effectuate that kind of change? I think regulatory boards are extremely weak in evolving their relationships with the legislatures. Doesn't mean you're lobbying. but it does mean you can be a very important information source to bring up issues like this that may come to your attention. So delegation of authority is super important. And again, as you can see, it's done in different ways: graduate, complete, school, program, APTA, CAPT, and then non-recognition of FSBPT, which is probably, if anyone was going to be recognized in the statute, it should be an organization like yours, as opposed to some of these others. So we bring this up just as an identifier. I understand this is a political process, a legislative process, and you may not have the control over it. So I'm not saying this in a critical sense. I'm saying it more in a learning sense of identifying language that may work, and in some cases it may not work as well. And if challenged, what might that lead to? Continuing with Virginia here, the Board of Physical Therapy shall regulate the practice of physical therapy and carry out the provisions of this chapter regarding the qualification, exam, licensure, regulation, and shall have the general powers and duties of a health regulatory board. So here's a big blanket statement that is providing this kind of authority to the board itself, probably somewhat in an ambiguous sense, to allow you as a board then to carry out this particular intent itself. So another example of language while we were in the Virginia statute itself. And here's the composition issue of the board itself: 7 members, 5 of whom shall be physical therapists. And by the way, what's the definition of a physical therapist? Someone who's licensed? Or can I be a physical therapist and not be licensed in any jurisdiction? So what would I do in the statute? That physical therapist would be capitalized, and I'd find it back in the definitions that it refers to someone who's duly licensed by the board itself. So just an example of language for purposes of today's remarks. 5 of whom shall be physical therapists who have been in active practice for at least 7 years prior to appointment. So I'm not sure what active practice means. Is that full-time, part-time? You know, we could talk about that. You've also got a citizen member and a physical therapy assistant as well. So back to the composition of the board itself. You're all public members in my mind. Some of you bring expertise to the table, and I understand public members are statutorily defined, but maybe a conceptual basis, that's good language for us to think about. So know when to ask questions itself. So I suggest to you that you seek and rely upon legal advice. Your lawyer should be at every one of your board meetings. It's extremely important for lawyers to hear the background discussions as you make your way to ultimately deciding something, whatever it might be, and that they can provide you with advice as you go. I understand that sometimes the Attorney General's office may have multiple lawyers who come to board meetings and others, and you may not have the continuity you're looking for. I do hear that on a regular basis, but be that as it may, seek and rely upon that legal advice itself. And understand that you are to carry out the intent of the legislation. So as you formulate your thoughts and your questions for the lawyers or anybody else for your administrative staff, that you are thinking in terms of the statutory obligations and responsibilities and the parameters of the statute itself as to what you would do. And then lastly, absorb the information, interpret language, impart knowledge, and determine the eventual outcome of whatever it might be, whether it's an adverse action, or it's a promulgation of a regulation, or if it's simply the issuance of a license or the denial of a license, perhaps even more importantly. So know when to ask questions and be careful about channeling your inner lawyer self. So there's a couple of cases that I want to talk about as we kind of get near the end here, and if any questions come up, please ask those. But in this particular case, let me move my picture so I can remember here and see. This is a veterinary medicine case where a dog was taken in to a veterinarian. It had gone to multiple different veterinarians because of an emergency basis. The dog had ingested some things that weren't passing through its system. The veterinarian who first saw the dog referred it out, and then the dog came back and eventually performed surgery, which was unsuccessful, and the dog had to be euthanized. There was an administrative action brought against that particular veterinarian, and the veterinarian was disciplined for failing to provide professionally acceptable procedures, and missed some things, the blockage pattern and the radiographs, and perhaps should have acted sooner. That might have saved this particular dog itself. And so a little bit of a background of the fact pattern. Why are we talking about this case? One is, don't forget that no matter what profession a case addresses, it can be helpful to all of us in the regulatory community. This could be human medicine, it could be physical therapy, it could be social work, it could be psychology, it could be massage therapy and others. And those are the groups, by the way, that I do represent. And so just to give you a little flavor. So this vet case came up. Now, the important piece of this, and for purposes of our knowledge today, is that here in upholding the decision of the board itself, this appellate court in Arizona said a court may not function as a super agency and substitute its own judgment for that of the agency, especially in this case where factual questions and agency expertise are involved. This right there sums up why it is you all have to be such good board members. You have to understand your roles and fulfill them, because there is a deference factor that the judiciary should and will in most cases apply to defer to your decisions. You are the experts. So it may be interpretive of the language of the statute. It may be interpretive of the activities that occurred, or in this case, maybe didn't occur soon enough. And ultimately, is the public going to be better off? So importantly, this court recognized the deferential treatment that it should give to you as an administrative agency, as a board, at least here in Arizona, related to factual questions and where agency expertise is needed. So if you don't bring that kind of perspective to the table, then we're defeating the entire purpose of why the administrative arm, if you will, of government exists. So understand that and take that into consideration. This is just one case, one example, lots of different fact patterns related to that. Now, to one of the questions that may have come up here a little bit earlier, and let me move my pictures again so I can read, is this issue of ambiguous language. Within this, this Arizona vet case, the court cited other cases, a 1989 case and then another 2021 case. And you saw perhaps that the vet case is very recent. I believe it was determined on March 9th. But anyway, so the court here is saying the term unprofessional conduct is a sufficient directive to guide the board in the exercise of its delegated discretion. So there's a good example of saying unprofessional conduct, albeit ambiguous, is subject to interpretation of the board. You're the experts. You can decide what constitutes unprofessional conduct. We need catch-all phrases within the statutes to capture, if you will, the unanticipated issues that might surface. Not everything is easy as a criminal conviction or a DUI or an obvious malpractice case. So this unprofessional conduct issue is a sufficient directive, meaning it will survive constitutional scrutiny. And then the case right below that as well, that Webb case is also, sorry, I'm moving the chat box so I can read that. Here in the Webb case, the court concluded that a standard of the following, this is a quote, any conduct or practice that is or might be harmful or dangerous to the health of the patient or public, unquote. That was not unconstitutionally vague, meaning it's okay to have that. So these ambiguous phrases likely can survive constitutional scrutiny if challenged, and that you then are determined to be the experts are making that ultimate decision. What's unprofessional conduct? What is conduct that may be, that is or might be harmful or dangerous to the public or the patient itself? So it's this type of authority granted to you with ambiguous language following is why it is so important that you understand your roles. And the last case that I'll talk about here is a New Hampshire case. This case, this is the March 9th case, excuse me. The previous one was this year, but a little bit earlier. In this case, the Board of Nursing in New Hampshire determined that nurse anesthetists can call themselves nurse of anesthesiology and or an anesthesiology nurse or some combination thereof. And I have the case here in front of me if anybody has a question, but they determined that. So this is one board saying that nurses can call themselves something. Well, we have another board, the Board of Medicine, that issued a declaratory ruling that the term anesthesiologist is limited to only those persons licensed as a physician. So now we have two boards, perhaps at odds with one another. This likely, in my mind, should be resolved between the boards itself, but obviously it wasn't, so it went to litigation. Now the judiciary gets to decide on behalf of one or both of these boards itself. Not always an enviable position. I'm sure that they attempted to resolve this matter, but they just couldn't come to common ground on this. Now, importantly, sorry, I'm moving these pictures around again. So I need to get better at doing this. Apologies. So importantly now, in the end, by the way, the court upheld the authority of the Board of Medicine to restrict or prohibit nurses from calling themselves anesthesiologists, even when the word nurse is attached to it. So, and apologies again for reading here, but two members of this court believe that the Board of Medicine's statutory authority is limited to physicians and that the statute does not authorize it to regulate the use of titles or specialties by non-physicians. So here's one interpretation, okay? And then the court goes on to say, or particularly whereas here the title at issue would be modified by the antecedent term nurse, which removed it from the Board of Medicine's jurisdiction. Is that enough? Can it be a nurse veterinarian? Can it be a nurse physical therapist? Can it be a nurse something? And does that make a difference? Now it says these two members of the court would hold that the Board of Medicine's declaratory ruling is ultra vires, and that simply means outside the scope of their authority. So they acted beyond what they had the authority to act as. And obviously from what they said here is because these two members of the court thought limited to physicians. So the scope of their authority is limited to physicians, and it's up to the nursing board to ultimately make a decision like this. However, two other members of the court agreed with the Board of Medicine that the statute broadly authorizes the Board of Medicine to regulate the practice of medicine, including the authority to limit the use of titles by non-physicians. And they would affirm the ruling of the board. Now, basically, by the way, procedurally, this is kind of a tie goes to the runner, and maybe I have that backwards. But anyway, the court ultimately said they upheld the authority of the Board of Medicine to prohibit the use of that phrase by nurses. So, but importantly, and the reason I brought this case to our attention here is this next paragraph. The court's disagreement on this issue evidences the degree of uncertainty regarding the extent of the Board of Medicine's regulatory authority. Okay. Clarification as to the scope of the regulatory authority of the Board of Medicine in this arena implicates public policy determinations that are better left to the legislature. Here's where they're saying, legislature, you step in. If we're wrong, then modify the statute itself. And so these couple of cases, I think, are just important indicators of why your knowledge, in-depth knowledge, whether you like it or not, and some of the legal issues that can arise out of this are critical to the effective and efficient operations of an administrative agency, of a board of physical therapy. And so it's incumbent upon all of us to hopefully help educate each other and participate in interactions like this and within your jurisdictions, and obviously through FSBPT as well. So there's plenty of cases out there that kind of flirt with these issues of delegation and recognition of the authority of the boards by the judicial branch of government. And these are really two recent, but I think very good examples. So what are we going to take out of this? Well, understand why government, although that was the last month's session, we touched upon it enough here to pull it within the realm of what we discussed today. know how it is that you are expected to carry out the intent of that legislation. And obviously you all know this, but be committed, attend, prepare, meaningfully participate in your board meetings, seek advice, and defer to counsel where necessary. These are super basic points, I realize that, but I'm hoping that the detail to which we discussed as we got to this take-home point helps add some of the specificity to this particular topic and these issues. And I got an unstable internet issue, so I hope you all heard that, and that did go away as well. So we are right on time here. We have just a couple of minutes left for potential questions. Or Nancy, if you have any comments that you'd like to make.
So thank you, Dale. There is another question, and it refers right back to your last statement on the last slide of defer to counsel. So you gave us the great advice to seek the advice of our attorneys. And I know that this will probably come as a shock to you, but how do you manage the reality of the Practice Act being interpreted differently between two different DAGs? You get one month and one another month, and they see it completely differently, particularly when the board, on the question of, does the board have authority to do whatever?
Yeah, that's a question that is not in. There's no easy answer for that question. So if you have this is with all due respect to the AGs and assistant AGs around the country, but you have a revolving door of assistant AGs that show up at your meetings and they have differing interpretations, you may have to go up the chain of command, okay, and ensure that the advice that you're receiving is the position of the Attorney General's office, him or herself. And so there's one of those types of approaches is to go up the chain of command. That's probably more of a last resort. You don't want to necessarily try to override the advice that you get, but consistent opinions is something I hear about relatively regularly, or inconsistent, if you will, advice from different assistant AGs. So that's not a great answer to your question other than keep asking the questions and have it be reduced to writing. And if need be, ensure that the higher ups, if you will, up the chain of command are in agreement with that interpretation. Now, ultimately, the board makes the final decision. So let's take a less controversial example of you want to promulgate a regulation. Your attorney is a little bit reluctant to say it may be outside the scope of your authority because you're doing X, Y, Z. You choose to do it anyway. Your lawyer likely is going to say something like, you do this at your own risk, et cetera. Now, if that's litigated, it's likely there won't be damages assessed against the board or board members itself. If you're the North Carolina State Board of Dental Examiners and you are dealing with financial driven issues and others, or at least accused of that, that may be a different issue. So that's a great question. It's a very difficult question to answer, but in the end, I like to say out loud, since this is being recorded, rely upon the advice of your lawyer.
And Craig did respond to that. When we defer to our legal representation, we don't like the counsel. Is it wise for the board to ignore that counsel? And I think you answered that. Do we have time for one more? Dale, can we do one more question?
Yeah, I mean, I stand as long as you guys tell me to stand, but we've got a couple minutes left, just 2 minutes.
Okay, so there's one other question here. I wonder if you have examples of where the disagreement over diagnosis has been resolved between the Board of Medical Examiners and the PT Board, or where manipulation has been resolved between the PT Board and the Chiropractic Board.
Boy, I sure wish it was 3 o'clock in my time here, so I could avoid that question. But I think, and this may not be an adequate answer. Number one is we accept overlapping scope of practice. Period. That's how it should be. The fact that chiropractors, physical therapists, and human medicine can all do something, there's nothing wrong with that. And to try to ever make the argument that we're the only ones that can do it, that is where you get into antitrust issues. That's where you garner the attention of the Federal Trade Commission, perhaps, and otherwise. So embrace the overlapping scopes. Now, if your scope says X and you interpret it to include something, so be it. Myself, if I represented your board, it wouldn't matter to me what human medicine said, as long as I thought that that was legally appropriate interpretation of the language itself. So embrace the overlap, because our time is up here, but embrace the overlap, but seek your advice and stick to your guns on an interpretive issue as well. And medicine may challenge it, just like they did here with the nursing board in New Hampshire. And, you may end up with a challenge. But last thing that I will make to that point is I always suggest to boards that they meet with other boards within their jurisdictions intra-state. So physical therapy, chiropractic, perhaps veterinary medicine, human medicine, have joint board meetings every now and then and talk about issues. So they're open to the public, so be it. And talk about issues, talk about the importance of overlap and where those lines may be drawn and perhaps where they may not be drawn. But I think that's good policy to meet with other boards to try to ensure that you are attempting to find the common ground rather than having a judicial fight about it.
Great, Dale. Thank you so much. As always enlightening, always terrific. We're getting great quotes here in the chat about, as usual, a stellar performance. So thank you so much. And thank you to all of you for attending. And we look forward to seeing you next week and seeing Dale again at the end of April. Take care, everybody.